I want to bring in my think tank tonight to talk about these huge developments in San Diego. Joining me in studio, we've got Stephen Burke, criminal defense attorney Jasmine Barber, and Michael Sterling, who's a former federal prosecutor and now a criminal defense attorney. Welcome to you all.
Thanks, Vinny.
Off the top, just let me know with one word, who's feeling better right now, the prosecution or defense?
Defense. Feeling real good.
I think the defense is feeling pretty good today, too.
Yeah, defense. It's gotta be defense.
I'm with you on that. So we all agree. Last night I didn't agree with anyone that was on the show. So we're off to a good start here. So, but they haven't sent out the note saying they're deadlocked yet. So from my perspective as a prosecutor, I'm thinking, well, they're still working through this, aren't they?
I thought the note was fascinating because it's just so basic in what is an oath. But it was
you're going with the oath note. Okay, let's put that, if we have that, let's put that up. And this was the note that was sent out today from the jury. The jurors could benefit from an explanation as to what being under oath means. Okay, so you think that's what?
Well, it's just so basic. Right? We would think everyone knows what an oath is, but it was also diplomatic. I mean, if that's the foreperson writing that note, maybe he's or she is looking for some direction from the judge. Hey, we're having trouble with one or two people, and if you could explain to these holdouts what's going on, what does this mean, that maybe they'll get the verdict that the foreperson is looking for. It's just fascinating to me what it says and what it doesn't say.
Yeah.
It's almost condescending, though. It's hard to get context from a note, but it seems like they're saying, Judge, there's clearly somebody here who doesn't understand what you told them to do. Can you explain that again? It seems like it could be a little condescending to me that there might be one person or two people who are holding out, not following the law and don't clearly understand the judge's instructions, and the foreperson may have been frustrated and said, explain this to them again, Judge, in a way that they understand it.
Now the fact that they're not deadlocked, Jasmine, they haven't sent out, that's the note that I always feared as a prosecutor. We are deadlocked, because that means, all right, I either have to do this again or I got to cut him some super duper deal down the road, right? But that hasn't happened yet. So this jury, I think, still believes that they can come to an agreement.
Yeah, I definitely believe that they're working hard to try to come to some kind of agreement. And I also think that the question that they posed speaks to the fact that they're struggling with the credibility of the different witnesses. So, I mean, my hope is that they will find a way to come to a unanimous verdict, and hopefully sometime soon.
What happens sometimes is jurors will say, hey, we've agreed on 3 counts, but we can't agree on 2. And sometimes the judge will say, ask the defense and prosecutor, hey, do you all want to just move forward on the 3 they've agreed with and hear their verdict, and I can declare a mistrial on the others. But they've given no indication of either direction, whether it's completely deadlocked on every charge or whether or not they've agreed on some charges but can't agree on them all. So it's the jury sort of left us in the dark here. They haven't given us any direction as to where they are.
The only thing we've heard,
vote count, vote count, 10-2, or
no vote counts, right. Nothing like that. The first question was something relating to Jane Doe number 3, and then the next one was a readback about Jane Doe number 4, and then today's didn't reference any of the Jane Does. So some of us were thinking, Stephen, that, hey, a question about 3 one day, a question about 4 the next day, maybe they're just moving all the way through this. But then today, leaving a half hour earlier than they usually leave on their own volition, just exiting. Is it because it's Friday, or is it because, hey, we know that we're going to need a bunch more time here to figure this out?
You use the term own volition. I've never heard or seen a jury just on their own volition leave. I mean, you usually get released by the judge. So if that's actually how it went down, that's fascinating in itself.
Yeah, they're not going back into the courtroom, and they're basically told, and if it gets to a certain hour, the judge will shut it down, but they're just leaving. We're done. We're done for the day.
Yes, I think it definitely speaks to the fact that they are a long way from coming to a common agreement on that. So they may need a lot more time.
Quick survey here. Longest jury you ever had out?
We were out probably, went into a 3rd day.
3rd day.
My trials have been really short and sweet, so quick deliberations, quick verdicts.
Yeah, I had a 2-day, had a jury that was out for 2 days.
2 days. Yeah. Again, the longest one on court TV that I remember was 17 days. So it can go that far. Now, this is 12 counts, 5 different accusers. How does that work into the equation as to when you start thinking, this isn't going to happen? At what point? How many days? How many hours?
Well, you know, if you're the prosecution, you have to be a little concerned. And one of the things when I was, looking at the closing statements, I didn't think they were surgical enough in terms of really explaining each and every charge and then tying them. They did use a lot of emotion. They used a lot of, they evoked a lot of emotion about the accusers and what, Mr. Winslow allegedly did. But I didn't think they were surgical enough in giving the jury a roadmap to convictions. Which may be what the jury is struggling with as well. I don't think they had, when I was a federal prosecutor, I wanted to give you a roadmap to basically show you, hey, let me walk you to the conviction. Here's what you do. You consider this, and this, and then you convict them. I didn't see that roadmap necessarily.
Yeah, and let's go out to San Diego. R.J. Manuelian joins us, great criminal defense attorney who's been talking about reasonable doubt throughout. Haven't you, R.J.?
Yes, I have. And Vinny, do I do a victory lap now? I'm the one that said yesterday they're not going to have a verdict today.
Yeah, you were right on. You're absolutely right on. 17 hours, 38 minutes. What do you think of the fact that they left a little early today? They could have deliberated another 30 minutes or perhaps another hour if they wanted to, but they didn't. They just marched out of the courthouse.
It means they're not close, and they want to go home because they're tired. And that's something that they're going to pick up on Monday. I think we'll have a verdict probably by Monday or Tuesday.
All right, now, folks, he's the one who got us to this point. R.J. Manuelian did with his prediction. So we're gonna lock him in on that Monday or Tuesday. And that does sound reasonable. So what's it like for the attorneys and the conversation you have with your client at this point, right? The fact that, hey, they haven't reached a verdict yet. Because your client's going to be asking you, what does this mean? What does this mean? What does this mean? RJ, what do you tell him?
Oh, the longer it goes, the better it is. If they were sure that he was guilty, they would have found him guilty. And there is a Friday factor. I agree with your guest yesterday, but this is not a typical case. So that's why I didn't think they would come back on Friday. I would be telling Kellen Winslow, look, we got a juror note. One of the jurors is just asking a ridiculous question. That's good for us. It looks like it may be a hung jury on at least some of the counts.
Stephen Burke? What do you say? What do you say to your client? He's going to ask you, all right, you're the expert. I've never been on trial like this before. What does this mean? Where are we? What should I be thinking?
Exactly what you just heard. I mean, the longer the jury is out, the better it sounds for the defendant. I would be telling my client to be confident. Monday will come around, and hopefully we're going to get what we want. A lot can happen over a weekend. When people are home alone thinking about what's going on, and they show back up on Monday, I've had some quick verdicts on Monday morning.
You have. The only Monday morning verdict I remember from Court TV, and this was an amazing one, was in the Scott Peterson trial out in California. And that jury was sequestered during deliberations. And we thought they were coming back Friday, just like I thought today were coming back Friday. And they didn't. We were surprised, and they were locked up in their hotel all weekend long. They came back. It was like first thing Monday morning, very early in the morning, they had a verdict. And I was baffled by it for years until I interviewed the jury on my radio show. And I asked them the question, we all were expecting Friday, and then you came back Monday. And they said, well, we actually reached the verdict on Friday, but one of the jurors was a single mom, and she wanted a weekend away from her kids. So they decided to sleep on it just to make sure and deliver it on Monday. But these guys and gals, this jury is not sequestered, so I don't think there's any chance that they're sleeping on anything this weekend, right?
Right.
It's just a reminder that juries are unpredictable.
Yeah.
When you put 12 people in a room and ask them to make difficult decisions, and you put all of their life factors and everything, bottled up in that one room, juries are extremely unpredictable.
All right, folks, you are our 13th juror. We want to know your reaction to what's happening tonight. Are you surprised by the length of deliberations? Go to our Facebook page. Our handle is Court TV. Vote and then leave a comment as well and respond to some of the other comments that folks are making. All right, folks, we're following some big breaking news in another trial that we are tracking. A judge in Massachusetts says a phone used by the young man who accused Kevin Spacey of groping him at a bar must turn it over to the defense. Spacey's attorney told the judge earlier this week that they need the accuser's phone because they believe the man deleted text messages that could help Spacey's defense. The judge gave the man's attorney 2 weeks to hand over the phone. Spacey is accused of groping a man who was then 18 years old at the time at a crowded bar in Nantucket back in 2016. And we'll be following this case very closely as it moves towards a trial. In the meantime, back now to what's happening in San Diego, which is the jury has left the building. They're done deliberating. They're done working for the week. They'll be back Monday, and our verdict watch will continue. So be sure to tune back in Monday here on Court TV. Now, in the meantime, one of the things I want to look at tonight are the promises that were made. And attorneys do this during their opening statements. They say, the evidence will show this, the evidence will show that, and you'll hear this and you'll hear that. They make promises to the jury. So we're taking a look at some of the promises from both sides to take a look at the promises that were made to see if they were kept. Right now, let's take a look at one of the promises made by the defense.
I would not dignify these things by calling them affairs, because they weren't. They were sex. No strings attached sex. It's wrong. It's wrong, it's immoral, but it is not illegal.
Is it your decision alone not to testify?
Yeah, I'm not going to testify.
Oh, all right.
Months prior to this assault, you guys had talked about money for sex. Yes or no?
I didn't talk about money for sex. He did.
But you
And I said, no, I'm not that kind of person.
She climbed a fence. She put her hands into a chain link fence and climbed over a fence. Took the care to throw her valuables over the fence and did it again. It's not a victim.
Me and him ended up walking upstairs to a bedroom.
Did you go on your own free will?
Yes, clothes started to be removed. We were kissing, touching, starting to have sex.
Were you basically hooking up with somebody you had just met?
Yes.
Okay, so the promise made by Brian Watkins, Kellen Winslow's attorney, during his opening statement was that, these encounters, they were consensual. It was no strings attached sex. Consensual, not rape. Did he fulfill, did he keep that promise? Well, Kellen Winslow II didn't testify and say it was consensual, so that didn't happen. But what did happen, Jane Doe number 2 was questioned about some talk about money for sex during some encounter that she had with Kellen Winslow II. She denied ever asking for money. She said that Kellen Winslow II offered it. Then Jane Doe number 1, it was pointed out that during their encounter, Winslow II is on the other side of the fence and she climbs over that fence to be with him, then climbs back over to be with him, gets back in the car with him. Does that prove consent? Does that fulfill the promise that was made? And then Jane Doe number 4 did testify about a prior consensual sexual encounter with Kellen Winslow II. But how about for the rape? Was there any proof of consent there, of it being just no strings attached sex? Was the promise kept? R.J. Manuelian is out in San Diego outside the courthouse. Did the defense keep their promise there, that this was no strings attached sex?
I think so. I think there was implied consent with Jane Doe 1. She had many opportunities to run and yell for help. She threw all her luggage over and things over the fence just to have sex with Mr. Winslow. I don't think that the jury's going to find him guilty on that count. I think he did deliver on Jane Doe number 2 as well. I think that there was a lot of inconsistencies with her testimony. And as far as Jane number 4 is concerned, she had consensual sex before. I just think she regretted what she did with his friend Matt. And I think it's a money grab with number 4.
All right, Jasmine, what do you think? Do you think that the promise that was made, that this was all just no strings attached sex, was kept by the defense?
I tend to actually disagree, because with the number of victims that have come out and made these allegations against Mr. Winslow, I think that it is counterproductive to the defense's case about implied consent or even actual consent.
I mean, I think consent is a defense to the kidnapping and to the rape charges, but it's not a consent to the lewd acts. And so I think I think that's probably one of the problems they're running into, is that
was there enough for this jury to say, hey, he said this was no strings attached sex, and they can have this argument in that jury room, and there could be people saying, yeah, this was just consensual?
There's enough circumstantial evidence for the jury to reach that conclusion, depending on the credibility of the witnesses. I think that, juries get to evaluate their credibility. They look at the circumstantial evidence. There's enough circumstantial evidence for them to reach a conclusion either way, in my opinion.
Stephen, the best way to prove consent is to have one of the people engaged in the sexual act get on the witness stand and say it was consensual. I know he doesn't have to, folks. I know that can't be held against him, but does it make him fall short of keeping the promise by not having that type of evidence?
I think it was the right idea to not have him testify. And clearly, we're going into the weekend and they still need to deliberate. So certainly the seed got planted by the defense that he did not need to testify. And I think the reasonable doubt is knocking on the door right now.
You're talking about the seed getting planted. Do you think, RJ, let me ask you about this out in San Diego. He brings up the notion of consent during the opening statement, which I think is brilliant, because now when the jury hears all the evidence and the testimony related to these women, they're always already thinking like, all right, is this consensual or not? And is that enough even without Kellen Winslow saying it was consensual? Just the fact that they're now listening to the testimony through that filter.
Well, just the way the prosecution could prove a case through circumstantial evidence, the defense has done the same. Mark Carlos has pointed out through circumstantial evidence, through the acts of Jane Doe number 1, that she impliedly consent and she wanted to have sex with Winslow. It's clear by her actions. It's not reasonable for her to do all those things and claim that she was kidnapped or under duress. I think the jury's going to see that.
You're nodding your head, Michael.
I think he's absolutely right. The circumstantial evidence is there, especially when it comes to the credibility of the witnesses, particularly Jane Doe number 1. I mean, you've got enough circumstantial evidence to say, well, these are some strange actions for somebody who claims to have been kidnapped and raped. These are some very, strange, awkward actions that you would hop over a fence, that you would throw your luggage over a fence. And then when you talk about the exchange of money, Mr. Winslow paying them, and then Jane Doe number 4, I believe, is the one who actually admits that she did have consensual sexual encounters with Mr. Winslow prior. So there's enough there, enough circumstantial evidence there for the juries to believe that there were consensual, that these were acts of consent.
Yeah, and that could be what they're doing right now. I mean, that could be one of the big debates here, right? Is exactly what was the nature? Because there's no argument, folks, that it didn't happen because we've got the DNA, right? We've got the DNA. Here's my question, though. If the DNA wasn't there, would they still say it was consensual, or would they say it never happened? Just thinking out loud. All right, our 13th juror question. Are you surprised by the length of jury deliberations? The time is right there on the bottom of your screen. It's been 17 hours, 38 minutes, 13 seconds over the course of 4 different days, and it will continue on Monday. Go to our Facebook page. Let me know. All right, our big breaking news out of San Diego, folks, and it surprised me a little bit. I am being 100% transparent. I was thinking Friday verdict, but it didn't happen. The jury is gone without reaching a verdict. They will be back on Monday. So the total time, 17 hours, 38 minutes and change. Some questions, some readbacks. They took a couple breaks. They left a little early today, but the bottom line is they are gone. But something happened today that has a lot of folks scratching their heads and wondering what exactly is going on inside that jury room. It was the note that I have right here. Let me show it to you, and I'll read it to you. This is the note sent by the jurors earlier today. The note reads, "The jurors could benefit from an explanation as to what being under oath means. Additionally, how we should follow the law and not what we think the law should mean." Wow. I've never seen a note or a question quite like that before. And my take is the judge didn't either, because he did not respond well to it, all right? Take a look, because it's not just about the note, it's about the judge's reaction to the note, my biggest moment of the day.
I won't tell them what the maximum punishment is. I will just say that it's the testimony is subject to penalty of perjury, and that sworn testimony not only consists of testimony from the witness stand here at trial, but also any other court proceedings, including a preliminary hearing. All right? And if they want further definition, I can provide that.
Yeah, it should say what an oath is, and the oath is to tell the truth, the whole truth, and nothing but the truth.
All right?
Your Honor, again, I don't think that that's necessary. They've been present for each time every single individual witness has been sworn and testified, but the court simply intends to state that sworn testimony means that it's subject to penalty of perjury, and that it would include both testimony at trial and pretrial hearings. Then we'll submit on that.
All right? How about,
It is necessary because they're specifically asking for it.
well, I'll define it. All right, what about the next question?
As to the second one, Your Honor, I would request that is something that I don't believe the court can really say, other than you have the jury instructions in front of you, that's the law and you need to follow the law.
Well, jury instruction 200, Calculum 200 states you must follow the law as I explained it to you, even if you disagree with it.
Right.
And I went over this with them during jury selection. That is one of the questions that was on the questionnaire that I gave to them. Can you follow the law as the court shall give it to you, even if you disagree with that law? They all said they could, and they all said they could, by the way, under oath, which gets to their first clarification. So I will remind them of that jury instruction. And I even told them, I explained to them why it's important to have uniform laws applied throughout the state. I told them the same law that applies in this courtroom has to apply in a courtroom across the hallway, a courtroom in Mammoth Lakes, California, or a courtroom in Sacramento, California. The law has to apply equally and the same in every courtroom across the state, and we can't have a different law applied just because we happen to have one or two jurors who think they should legislate a new law in a jury room. So I will explain that to them.
I can understand the judge being a little upset, right? The judge is in charge of the law. He instructs them on what the law is, and they already took an oath to follow the law, and they're saying, well, how should we follow the law and not what we think the law should mean, Judge? So then it was time for him to bring in the jury and explain this to him. Take a look.
The note reads as follows. There's two sections of the note. The first part says, the jurors could benefit from an explanation as to what being under oath means. So I will explain a little bit further what being under oath means. You have all heard every witness who comes into the courtroom take an oath to tell the truth. And that is an oath where they have to agree to tell the truth, the whole truth, and nothing but the truth. And that oath requires them to, when they take the stand, not only here at trial, but also at the preliminary hearing that was held some time ago, that requires that witness to testify truthfully. If they do not testify truthfully under oath, they are subject to the penalties of perjury of the state of California. Now, I hope that answers the question, but when somebody takes an oath to tell the truth, they have to tell the truth, the whole truth, and nothing but the truth. And you heard over 30 witnesses stand before you and take that oath. It's an oath that's administered by the clerk, and it subjects them to the penalty of perjury if they don't. The next question, well, it's not really a question, it's a statement. It said, additionally, how we should follow the law and not what we think the law should mean. And we went over this. Now, it's been a while. It's been, 3.5 weeks since we went through jury selection. And if you recall back to those times, there was a question I put on that jury selection questionnaire that asks you if you can follow the law as the court explains it to you, even if you disagree with the law. And speaking of taking oath, you all said under oath that you could follow the law as the court explains it to you, even if you disagree with the law. And you may not remember, but I went through an explanation explaining that the law has to apply equally in every courtroom throughout the state of California. The law that applies in this courtroom has to apply in the courtroom down the hall. It has to apply in a courtroom down in Chula Vista within San Diego County. It has to apply in a courtroom up in Mammoth Lakes, California even. It's the same throughout the entire state. We cannot have a different law being applied in any courtroom anywhere in this state just because a juror or some jurors happen to disagree with that law. The court instructed you, you must follow the law as I explain it to you, even if you disagree with it. If you go back into that jury room and you look at Calcrim number 200, it says it right there in plain English. It says you must follow the law as I explain it to you, even if you disagree with it. It doesn't say you can follow the law or you may follow the law if you choose to. It is mandatory language that you absolutely must follow the law as I've explained it to you. Now, if anyone feels as though they can't follow the law as I explain it to you, I need to know about it. You send out a note. If someone doesn't feel they can follow the law, you send out a note and you let me know and we'll deal with it, okay?
Did you ever have one of those moments where a light bulb goes off over your head and it's like all of a sudden this thing is very clear? I just had that moment of clarity listening to this again, reading the note again, and listening to my guest Michael Sterling, who was here, and his take of this whole thing. And let me bring in Chanley Painter outside the courthouse, our Court TV legal correspondent. Chanley, let me tell you what I am now thinking and believing about this note. I was always looking at it as two separate inquiries. I see it as one inquiry now. And I don't know why I didn't see this before, but Michael Sterling is saying it. You're nodding your head as well. That it's about the oath the jurors took and the oath to follow the law. It's all one note. It's one idea. It's not two separate inquiries here. Am I seeing that right now? And I think I was seeing it wrong all day long. Chanley?
Well, possibly that could be. That's one way to think about it, but I do know that when I was in there as the judge was instructing the jury, I had different reactions. I had different jurors nodding their heads during the first part that were nodding their heads during the second part, if that makes a difference. I think I may have told you earlier, but for the first one, what under oath means, I noticed that juror number 12, 1, and 6 were nodding along to the judge answering that. And then for the other question about following the law, we saw number 4 and 5 nodding along and looking at 12 and 6 as the judge was answering that. So I don't know if that supports or doesn't support what you think may now be the indication with that note.
Yeah, and this is what I'm going to do. If we could put the note up one more time, and I'm going to just change one word. You see the word additionally? Get rid of the space in between and replace additionally with the word and, right? The jurors could benefit from an explanation as to what being under oath means and how we should follow the law and not what we think the law should mean. All of a sudden, that is just one thought, that there's some jurors in there who are not following the law, whether it's one or more, and it seems that juror 6, like Michael Sterling, I'm going to bring you in a second, Michael, because I see you. How juror 6, who's the foreperson, Chanley, is trying to get this jury to 1 or 2 or 3 or 6 to just follow the law because their oath was to follow the law. What do you think?
Very could be. I can tell that number 6, we know him, he's a COO of a school. He's used to managing people, and it seems like he's trying to lead this jury, almost moderate maybe different opinions to get them all on the same page. And that's why he seems to be writing down these questions. The timing of this question was interesting, Benny, because it was in between the reading of Jane Doe number 4's testimony and Nicole Edwards as they took a break. It wasn't like it was in the first thing in the morning or after they were deliberating. It was kind of on his own volition. He gave that to the bailiff. So that was interesting as well.
Do we know if he wrote it while he was in the jury box, or?
That's what it looked like.
Wow. Okay. This is unbelievable. I can't believe it. This is why we invite the smartest people on the show, folks. Let me bring them back in, my think tank here in studio. Stephen Burke, Jasmine Barber, and Michael Sterling. Michael, I'm going to start with you because I've been talking about you the whole time, right? Because I heard you, and then I read it, and then boom. So,
well, first of all, I think the judge made sort of that same assumption because he gave a very narrow definition of what under oath means. So he didn't talk about what being under oath means. He talked about what a witness, swears to do when they take the witness stand. Because the jurors took an oath, the witnesses took an oath, and those oaths were very different, right? The jurors took an oath to follow the law as the judge described it. The witnesses took an oath to tell the truth. I think the judge should have been broader in his explanation of what being under oath meant, but everybody sort of jumped to the same conclusion that they were referencing the witnesses and not generally speaking what an oath actually means. And then the COO of the school, I think, spelled additionally wrong.
Yeah.
But yeah, I think this was to me, when I read it initially, it seemed like they're having a problem with someone in that jury room who was saying, well, I think this or I think that, and they're trying to get that person to understand, no, we took an oath to do what the law says do, and we should follow the law, not what we think the law should be. And I think they were trying to get the judge to give that individual or those individuals an explanation about that.
This now to me seems totally like a jury issue, not a credibility of any witness issue.
I definitely agree with you, Vinny. This smells
You
like
agree with
jury.
Michael. Let's give him credit.
Michael,
Continue to give him
I
credit.
agree. Yes, but this smells like jury nullification. Someone in there is saying they don't believe that they should convict for one reason or another. It's interesting to see it.
You think it's that way? You think
I do.
You think not following the law is helping who?
The defense. I definitely
help
think
the defense.
it is helping the defense. Absolutely, because I feel like somebody is just like, maybe they are a Kellen Winslow fan and they just don't want to see him go down, and they're just like, well, I don't believe what witness Jane Doe 1 or Jane Doe 4 or anybody said, and I just don't believe he's guilty. And jury nullification is the word that keeps jumping out.
Yeah. So Stephen, if someone's not following the law here, do you believe that person is going to help the defense or the prosecution, this one or more jurors who apparently is not following the law?
Again, the longer the jury gets hung up, the better it is for the defense. So it's moving in the right direction for the moment.
All right, R.J. Manuelian out in San Diego, great criminal defense attorney, has been spot on throughout this trial. My new interpretation, my new understanding of this note, courtesy of Michael Sterling, once again, ladies and gentlemen. If there's a juror or jurors who are not following the law, does that help the defense or the prosecution? Who do you believe it helps?
I think confusion and chaos are Mr. Winslow's best friends right now. And if you have a rogue or clueless juror, it's only going to help Mr. Winslow, because at the end of the day, it might be another Phil Spector situation where you get an 11-1 guilty, and all you need is one juror to basically block the field goal. And that's what the goal of the defense is.
You remember all the trials, RJ. It's amazing. And you remember the jury counts. That's unbelievable. I told you we bring on the smartest.
I do.
All right, our 13th juror question for you folks at home. Are you surprised by the length of jury deliberation, 17 hours, 38 minutes? Let us know on our Facebook page. Leave a comment. Also, respond to some of the other folks. Let them know what you think.
That's when you saw him do this movement that you're talking about.
Yeah, he came right in front of the machine that I was using, right on my face.
Okay. And standing in front of you where the machine was at.
Yes.
Yes? Okay. And you said that he had an erection.
Yes.
Okay. And you've never seen this man before, right?
I saw him in the news when he was arrested.
Okay. So he's standing in front of you, and this erection that he has, does he pull it out of his pants?
No.
Does he grab it with his hands?
No.
Does he masturbate at all?
No. But he pointed to me and he said, "Do you see this?"
That was the testimony of Jane Doe number 5. Remember, a 77-year-old woman. And this all happened, allegedly, after Kellen Winslow is out on bond facing rape charges. So he's waiting for his trial and gets arrested for allegedly exposing himself and some lewd conduct at the gym. Twice with this 77-year-old woman who came into court and testified. Now, what I want to do right now, during the opening statements, and both sides did this, the prosecution and defense, they made some promises. The evidence will show this, you will hear this, and you'll see this, right? Well, there were promises made by the defense about this particular Jane Doe, and there was a promise about what she wouldn't testify about, what she did not see. The promise was made. Was the promise kept? You be the judge.
never saw him nude in any way, shape, or form. She didn't even look at him. In fact, we find out later that there was another guy in the jacuzzi that didn't see any of this.
Did you see an exposed penis?
No,
Right. Did you see the towel come off of Mr. Winslow?
no,
Did you see the flap of the towel open and expose any part of Mr. Winslow's genitals? Yes or no?
I did not.
You must adopt the one that points toward innocence, because she didn't see anything. There wasn't anything there, and even worse than that, there was somebody else there. There was another man in the jacuzzi with Mr. Winslow in this exposed penis underneath the water masturbating himself. Do we have the complaint from that guy? Do you think that we might have heard something about it?
Now, the other part about that person who was in the jacuzzi, they were the first person to leave the jacuzzi, so why did that person leave is a question I would have raised as a prosecutor. But was this a promise that was kept by the defense? My think tank is back with me, and I'll begin out in San Diego with R.J. Manuelian. R.J., did the defense keep this promise?
I think so, but you know what, Vinny? I'm not really worried about the lewd conduct, because the more serious conduct is Jane Doe 1, 2, and 4. Even if Winslow is convicted on the lewd conducts, which I think he will be, he could face probation. He could be released. The big bullets are Jane Doe 1, 2, and 4.
All right, so I'll bring it in here. Stephen Burke, do you believe the defense kept this promise that, hey, she never saw him nude?
Generally, they kept their promise, and I also do agree that the misdemeanors obviously want to beat every charge. The misdemeanors are not the big problem here.
But do the misdemeanors somehow color the rest of the charges? Like if someone's going to get into a hot tub and sit right next to a 77-year-old woman and do what she says he was doing underneath the water, isn't that someone who might be a little more likely to maybe rape someone?
Certainly the prosecution was hoping to color everything with the other things. So, yeah, I mean, every part of this is a problem, and the defense has done a pretty good, thorough job about breaking down each individual charge and each individual Jane Doe.
Was this a kept promise?
I do believe it was a kept promise, but I think that his behavior, especially while he was out on bond, tends to show the prosecutor's case where they want to show he has a propensity to commit these kind of crimes. You want to tell your clients that, while you are out on bond, I need you to be on the straight and narrow. I need you not even to jaywalk. And so for him to continue to allegedly commit these acts, I think, does tend to lead to the propensity that he has to commit these crimes.
Promise kept. He didn't expose himself. They were able to, get that out through that witness. He didn't expose himself. There was somebody else there. Why would you do this act? Where's that other person at? Where's the prosecution at in terms of doing their investigation? And I think it was a promise kept. And I love the fact that the defense team does not leave any assertions unchallenged. I love the fact that they're attacking this thing all the way and saying, look, our guy didn't do it. She saw him on the news and, was aware of these allegations. And then she comes forward and says he did this thing that he never did.
Is there a concern that the folks on this jury are from this community, right? And this is a guy they know that, they were tracking him, and he's going to like local gyms and doing this to complete strangers. Does the jury become a little more protective of their own community and maybe look a little harder for a road to conviction to keep this man off the streets?
Not if they're following the judge's instruction, which was they had to, one, presume him innocent at the beginning of trial, and then they had to follow the law. So if they're following the law, they can't concern themselves with anything else other than the facts of what they heard in testimony and the law that they heard in a courtroom. So if they're doing what the judge instructed them to do, what they asked for an explanation on from the judge in the last question of the day, then they should not be thinking about what else is happening or what the consequences are from them doing their job, their oath.
RJ, do you agree that the law in this case, if it's followed precisely, favors the defense and reasonable doubt?
Yes, the key question is if. We don't know what they're doing in there. They could just be doing what their gut tells them. And Vinny, doing this as a prosecutor, sometimes the jurors go with their gut and they disregard the law. And we're seeing that right now with one of the jurors with the notes that they're writing. It's just ridiculous not knowing what an oath is. So I think it's good for the defense. I believe that there's going to be some hung counts. I don't think they're going to be able to find him guilty on the counts that I said, but that remains to be seen. We're going to come back next week and find out.
Jane Doe number 5, one of the most interesting ones here because, and when you look at the actual charges, Jane Doe number 5, there's a bunch of charges involving her because there were 2 different incidents, and it includes willful cruelty to an elder and battery against an elder. So playing up the fact that she's 77, does the age factor overall play any factor, you think, into the deliberations here? Do you think the jury has noticed, because prosecutors really didn't point it out, the fact that all of these victims, except the one from 2003, are significantly older than he is? Do you think they're thinking about that or don't even care?
Yeah, I think so. I mean, I think that, you have to consider each and every witness. You have to look at, their life experiences and what they've gone through and, and whether or not, as you think about whether or not to give weight to the credibility of their testimony. I mean, I think jurors, this jury was really observant. They paid a lot of attention, took a lot of notes. I think they caught on to the fact that she was an older woman, that many of these victims were older.
All right, we've got a 13th juror question, folks. We're going to reveal the results very shortly. Are you surprised by the length of jury deliberations? We post it on our Facebook page every day. Very easy to find. Our handle is Court TV.
I'm Yodita Walde. As a defense attorney, I fought for my client's constitutional rights. As a prosecutor, I worked to convict the guilty. On Court TV, you and I will hear both sides.
An innocent man has been falsely charged.
Examine the evidence.
He is in fact guilty of murder.
And uncover the truth together.
The all-new Court TV, your front row seat to justice.
I was terrified.
Yeah,
I thought he was a terrorist.
You didn't? Oh, he's a terrorist now.
Well,
Objection argumentative.
Sustained is the last. That wasn't a question. You can ask your next question.
Why did you think he was a terrorist?
just the way he acted.
What about the way he acted made you think he was a terrorist?
Well, if somebody told you and they kill you and rape you, and I just thought he was a terrorist.
And you thought he had a gun.
I thought he had a weapon.
And that's because black people always have guns, right? That's something you've said before. Remember that?
Yes, I did say that.
You told police it's usually the black guys that got guns, right?
Yes.
That was the cross-examination of the first accuser, Jane Doe number 1. And that was cross-examination by the defense. But during his opening statement, the prosecutor, Dan Owens, talked about Jane Doe number 1 and promised some evidence and told a story about the blood. So what I want to do right now is replay for you that promise that was made so we can debate whether or not that promise was kept. Take a look.
The pain that she felt was so tremendous that she said she felt herself begin to bleed. That it was when she began to bleed and she was not menstruating, but that as she began to bleed, the defendant just stopped. She thinks that may be why, but ultimately when he stopped raping her, he told her to get out of the car. Did you notice anything about the white pants that were on the top of the laundry basket on March 18th?
They were stained with blood.
Did you see where there was blood on the pants?
It was in the crotch area.
The evidence of the blood is still important because menstruation or not, there is no blood inside of the Hummer. Zero.
Did you ask your mother about that?
I did, but the way I phrased it was, "Oh, you ruined your pants." And what she replied was, "Yeah, I'm on the rag."
All right, so Jane Doe number 1, the promise was that the evidence is going to show that this was a rape that was so brutal that she felt the blood gushing and that she was bloodied from this attack. So the question is, was there any evidence of that bleeding? Well, you heard during the course of this case that the forensic evidence in that front seat where this rape allegedly took place, there was no blood found, but they really didn't look for the blood there. I mean, but they didn't find any and none was presented. So was this promise kept? There was some testimony about bloody pants, but what was the cause of the bloody pants? Was it the rape or was it menstruation? I mean, that's really the issue here. So the question I have tonight for my think tank, did Dan Owens keep the promise that he made during that opening statement? And I'll begin here in studio. Jasmine, do you think that promise was kept by the prosecutor?
Honestly, I don't think that promise was kept by the prosecutor. And coming from the perspective of her daughter told her, or she told her daughter that she was on the rag. And the fact that her daughter believed that is, I think, a testament to the fact that, you know, the blood could have definitely come from menstruation.
Broken promise?
It looks like a broken promise to me.
And what impact does that have? No blood is found on the front seat. That's the scene of the alleged attacks here in this case. And there's no real search for the blood, but they don't present any to this jury.
Jane Doe number 1 seemed to have some problems throughout her testimony. The cross-examination was good to expose those difficulties that she presented.
I mean, I think to be fair to the prosecution, there is enough circumstantial evidence that they presented. Obviously, her testimony, which is evidence. Now, whether or not the jury gives credence to her credibility is a different question. But she did testify that as a result of Mr. Winslow's attack on her, that she was bleeding. So there is evidence that happened. And then you had the surprise witness, which was her daughter, who came in and said, yes, I remember seeing those same bloody pants that day. So there's some circumstantial evidence for the jury to say, prosecutor made a promise, he kept it. Now, whether or not they believe it, give it credibility, there's also an alternative explanation. As Jasmine mentioned, that it may have been for menstruation, but there was some circumstantial evidence to give the prosecutor a way out to say, yeah, I made that promise and I kept it.
RJ, do you think that promise was kept?
Absolutely not. As you know, reasonable doubt is the highest level of certainty required under the law. That has not been met. I think that there's some speculation, and there's a jury instruction that says if there's two inferences, one points towards the defendant's guilt, one points towards his innocence, you're supposed to go with the evidence that points towards his innocence. In this case, she could have been menstruating. There's a lack of evidence as to whether or not the alleged rape caused her to bleed. So from that perspective, I don't think Dan Owens made his case or kept his promise.
And in this case, you talk about the forensics, and in these days, we always talk about the heightened expectations of jurors, especially with shows like CSI, where things are solved, because of the forensic evidence that is left behind, and they find that one speck of blood, and they figure it out. They put that special light down there, and they can test it, and there's someone with a lab coat who can figure the whole thing out. That didn't really happen here. You did have some forensic evidence, which was the DNA that linked Kellen Winslow to both Jane Does. So you do have that, Jane Doe 1 and Jane Doe 2. So you have that here, but you don't have the blood. So do you think that the expectations of the jurors these days are so high that there's a feeling that they're being let down by what wasn't presented by prosecutors here?
I hear prosecutors all the time telling juries that this is not CSI, and just because we don't have all of that doesn't mean it didn't happen. So it's a case-by-case basis on what a jury's going to believe. Some of them have a true expectation that they should be able to see all of the CSI information they're looking for, and some folks understand that that's just TV. So,
yeah, and there's no swabbing of the front seat, and the explanation was because of the leather, it would have wiped off, and they were examining it months later, but still, if it was that bloody, maybe that blood could have gone in some other place in that front seat, maybe down the carpet, or if there's some way to tell that blood had at one point been there, some sort of testing like that. But that seemingly didn't happen here, Michael.
And the defense pointed that out, over and over again. And
there's the front seat. We're looking at the front seat right now. Now the back seat, and they found DNA in the back seat from Kellen Winslow, by the way.
Right.
But there were no alleged attacks. I don't even know why they're searching the back seat, but they found it in the back seat, which makes them look kind of creepy.
And I think the defense pointed out that there were specific, in cross-examination of the detective, that there were specific tests that the detective could have used that would detect blood, and that there was, and it would be impossible almost to get rid of blood. And you could even find blood in places and spaces in a car that you didn't know that it was there. So I think they pointed that out. But yeah, I think the lack of, but the like to my colleague's point, the lack of the CSI material doesn't necessarily mean mean that the jury won't believe the witness. So, witness testimony is evidence. And if somebody says says this happened and it happened that way, and the jury gives them credibility and the jury believes their story, that's evidence.
Yeah, and witness testimony, by the way, is direct evidence. And you know what happens in most criminal cases, and I've got criminal defense attorneys here, so I'm going to put them on the spot. In most cases, defense attorneys get up and say, ladies and gentlemen, there's no direct evidence here of a crime. This is merely a circumstantial case. You cannot convict someone on mere circumstantial evidence. And now, in this case, there's direct evidence, but really kind of not a lot of circumstantial evidence. And in his closing argument, Mark Carlos actually said, ladies and gentlemen, you just have her testimony. They can't come in here and say they have any circumstantial evidence. So let this be a lesson. No matter what you have or don't have, the criminal defense bar will make it look like you messed up. Like you only have direct evidence, you can't convict. You only have circumstantial evidence, you can't convict. RJ, Manuelian, am I being fair to you guys here?
No, you're being very fair. Actually, I'll take it one step further. We're taught in law school that if the facts are bad, you argue the law. If the law is bad, you argue the facts. That's what a good lawyer does.
Absolutely. So, but I actually agree a little bit with what the defense is saying here, because the circumstantial evidence would support these witnesses who may have some credibility issues that I think everyone has acknowledged, that, one is bringing it, 15 years later, another one lied about about drinking. And there were some other issues that came up during the course of the case that the circumstantial evidence would have helped a little bit here.
Absolutely. When I was a prosecutor and you knew you were going to have credibility issues with the witness, you certainly wanted corroborating evidence, something to support their version of events. And I think if the investigators would have done a little bit more here and the prosecutor would have gotten them to do a little more, they may have been able to find some of that circumstantial evidence to corroborate their witness testimony and sort of shore up a witness who had clear credibility issues.
Yeah, if that blood was found in the front seat, how does that change this case?
Significantly.
I think we'd have a verdict tonight.
Yeah, we would not be talking about it right now.
45-minute deliberation.
Yeah, imagine if the prosecutor could have closed and said, you don't even have to, even if you don't, believe her, I know she has some credibility issues, but guess what? We did, an analysis of the front seat of that car, and there was her blood found there in the front seat of her car. You get to say that in closing arguments, case closed.
Yeah.
At the end of the day, even if the presence of blood was there, does that overcome the consent issue? Like the blood could have been there anyways, and it could have been still a consensual act.
Yeah, but it certainly would have corroborated what she had said, her version of events. So you would have at least had some corroborating evidence. I think that if you get that blood in the front seat, most people don't bleed when they're having sex. I think you get that blood in the front seat, it corroborates her version of events, that it was a forcible rape. I think it's going to be hard for the defense to overcome that if that had happened.
Yeah, RJ, is this a whole different case if in fact the tests are done and they come up positive for the presence of blood in the front seat of the Hummer?
No, because again, I agree with your guest. It's an issue of consent, and whether or not she has blood additional, I don't think it matters, because according to her daughter, she was menstruating, and so that vitiates any corroborating evidence that she has, in my opinion.
Okay. I told you that he's got an answer for everything. but the thing is, his answers have been right throughout this trial, so we have to respect him, and I absolutely do. Hey, let's take a look at our 13th juror question, folks. It all has to do with the clock on the bottom right-hand corner of your screen right now. You see those numbers? That is the amount of time that this jury has deliberated this week without reaching a verdict. Over the course of 4 days, 17 hours, 38 minutes, 13 seconds. Does that surprise you? Are you surprised by the length of jury deliberations? And we'll probably be able to continue to ask this question next week as they continue their deliberations. Go to our Facebook page. Let us know yes or no. We are following some other breaking news in another case that we are tracking, and this is the Kevin Spacey case. A judge in Massachusetts is saying that a phone used by the accuser who says Kevin Spacey groped him at a bar must turn it over to the defense Spacey's attorney told the judge earlier this week they need the accuser's phone because they believe he deleted text messages that could help Spacey's defense. The judge gave the accuser's attorneys 2 weeks to hand over the phone. Spacey is accused of groping this accuser, who was then 18 years old, inside a crowded Nantucket bar back in 2016. Let me bring in the think tank on this one, and I'll begin in San Diego with RJ Manuelian. RJ, I know you're very familiar with this case. This is crucial to the defense getting their hands on this phone.
Yes, they're digging for consent. And if they go inside those text messages and see that the boy was actually texting others, including his girlfriend, laughing it off, or any kind of implied consent language, they're going to use that to show there was no sexual battery.
Now, one of the allegations in the backstory here, and I've read through some of the documents from court, is that the accuser says he's on the phone either texting or Snapchatting with his girlfriend on and off for 3 minutes during the time which Kevin Spacey is groping him. So he says the groping lasts about 3 minutes on and off, and he's Snapchatting and texting with his girlfriend at the time. Michael Sterling, there's Kevin Spacey. Does he have a case? Does he have a good defense here, you think?
Well, I think we're going to find out, right? I think that's why the judge issued the order, I think correctly, to give Kevin's attorneys access to the phone so that they can make an image of it and look for exculpatory evidence. As our colleague in San Diego mentioned, there may be exculpatory evidence, whether that's a consent defense or whether it's some other defense that it never happened at all. Whatever it is, the defense deserves the right to be able to image the phone, get the forensic evidence off the phone. And then, we can we'll be able to make a determination very quickly whether or not there's some exculpatory evidence that could get this case potentially thrown out.
And this digital evidence is key to so many cases, but in this case, I mean, in the papers, in his statement that he made, he admits that he's on the phone at the time, so there's a lot of use. He's 18 years old, so these guys are sharing everything, whether it's on social media or texting friends.
My question right now is, he's obligated to turn over the phone. Is he obligated to open the phone, give a password up? There's a guy in Florida that just did 44 days because he refused to give up his password. So just having the phone is not everything. So I'm really curious to see how this develops and whether they're going to be cooperative or not.
Yeah, and what they get off this phone could be the key to the case.
It absolutely could be the key to the case. I think that, along with the potential exculpatory text messages, the fact that he was in a crowded bar and claiming that he was groped by somebody, he probably potentially could have exited that situation. So I think it definitely lends to the credibility of his statements.
And RJ, the other part of the statement that I read is that the accuser says he keeps hanging out with Kevin Spacey, and Kevin Spacey is hitting on him, according to the accuser, is because he's trying to get a selfie with him for his social media, whether it's Instagram or Snapchat, one of them, that he wants to post. And Kevin Spacey isn't taking the picture because he's telling him, if I take it with you, I got to take it with everybody. But really a strange fact pattern to this one.
Very, very strange. And I think it's all produced by his mother, who is I believe she's a Weather Channel person, or she's on some sort of media, she's a news reporter. She's the one that's been pushing this. I think she's outraged. I'm not so sure it's the boy that's pushing it. So I think all of this is going to come to fruition. The text messages, why he wanted Kevin Spacey to be on his Instagram account. Is this retaliatory because Kevin Spacey said no? All that's going to pop up. And more importantly, the defense attorney is going to ask this boy, why didn't you give the phone voluntarily? Why did you hold the phone back? The jury's going to listen to that. The credibility is going to be an issue in this case, and I think that boy's credibility is going to be placed on the line.
And RJ, I know you know the Kevin Spacey's attorney very well because he's from Los Angeles. What can you tell us about Alan Jackson, the attorney for Kevin Spacey?
Alan Jackson has tried one of the hardest cases. He's tried the Phil Spector case. He's tried some race car driver case, high-profile cases in Pasadena. He's a stellar prosecutor and a stellar defense attorney. I think that he is weeding out and parsing every single nook and cranny in this case. He's doing everything thoroughly, and I believe that if Alan Jackson really focuses on those text messages, he'll probably be able to get this case dismissed before it goes to trial.
Fascinating. And we're going to continue to cover this case for you folks here on closing arguments as we move closer to a potential trial date or another hearing date, and we'll see all the developments in what may or may not happen to Kevin Spacey. In the meantime, let's check back in with Court TV legal correspondent Shanley Painter for a look ahead to next week in the Kellen Winslow case after this week of no verdict.
Without reaching a verdict, the jury left the courthouse behind me earlier this evening, a little earlier than normal. They were ready for the weekend. It's been a long few days of deliberations here. They've asked 3 questions, sent 3 notes to the judge. Today was the most recent during the readback of Jane Doe number 4 and Nicole Edwards this morning. The jury asked about some definitions, what under oath means and what it means to follow the law. That was answered by the judge. They went and continued their deliberations today. They took an afternoon break, but we can tell that it looks like this is wearing them down a little bit. They were tired. We see some factions breaking off. What that means or if and when they'll reach a verdict, maybe we'll know Monday, Vinny, but we'll be back for deliberations 9 a.m. Pacific time, 12 noon Eastern Standard Time. So we will be live here then. We'll send it back to you.
All right, thanks so much, Shanley. Let's take a look at the results from our 13th juror question, which was, are you surprised by the length of jury deliberations? Only 37% of you are saying yes, 63% of you are saying no. Not surprised that this is a difficult case for this jury. 5 accusers, 12 counts, and some problems with each one of the accusers, but there are 5 of them. Those are the competing interests here in this case, which is what I think is making it difficult for the jury. The fact that if you look at each case individually, yeah, there's a problem here, there's a problem there, and yeah, there's another problem over here. But then you look at the big picture, right? The trees through the forest, the fact that there's 5 women coming forward and making these accusations. I mean, how many people can you think of that have been falsely accused by 5 different women who don't know each other? Has that ever happened in a case? You know, every night here on Closing Arguments, I usually ask my guests this question. I think I'm going to do it again. I'm going to ask it one more time. Let me go around the horn here. Michael Sterling, have you ever come across in your legal career someone who's been falsely accused by 5 different people of anything?
No, I have not.
You haven't?
It's not in my legal career, no. And I'm not saying it's not possible, but it's never happened in my legal career.
Oh, it's absolutely possible, but have you ever seen it?
I have never seen it. I don't think it's probable, like, to stack these on top of each other. I think that's why the prosecution wanted to keep the 5 women together, because independently, each one of these cases have problems.
Me too. Not had that problem.
Never seen it. And RJ, I've asked you that already on another night, so I know your answer already. I'll take judicial notice of it.